I'm Kate Simpson. I'm an accredited specialist in workplace relations law and the founder of Employee Safe Legal based on the Gold Coast. By now, employers are aware that from the 26th of August 2024, a right to disconnect appears in the Fair Work Act that applies to most employers, other than small businesses where it will apply 12 months later. However, employers have been contacting me and asking me about the modern award provision that has been inserted in relation to the right to disconnect. The purpose of this presentation is to explain what that modern award provision is and to give some tips on how to be compliant with that provision so that you can future-proof your business. The starting point for any discussion about the right to disconnect is, of course, the Fair Work Act. The Fair Work Act provision is focused on the behaviour of the employee as compared to the behaviour of the employer. The Fair Work Act broadly states that an employee must not refuse contact about work outside of work hours unless it's unreasonable to do so. What is unreasonable must be determined based on a range of factors. Those factors include, but are not limited to, the roles and responsibilities of the employee and whether they're getting paid for those additional hours. The modern award provision, however, is different. It goes a bit further in two places. So the first place is that it does place a prohibition on employers. It states that an employer must not directly or indirectly prevent an employee from exercising their right to disconnect under the Act. And this is where we have some controversy because this does place the emphasis on employers rather than employees, and it also uses a very vague and ambiguous term. That is the word indirectly, which isn't defined in the Act or the award. And when you think about it, it really has to go to the perception or the subjective thought process of an employee about a workplace situation. And wherever we do have that disparity between fact and subjectivity, it does give rise to potential disputes. The second change is much less controversial, and that is that it provides that an employer can contact employees in a way that's envisioned by the award outside of work hours, and they won't be in breach of the right to disconnect. So, using the General Retail Industry Award as an example, an employer can contact an employee about work outside of work hours in relation to an emergency roster change or a recall to work, as long as they do so in a way that's provided for in the award. So why have these changes been made, and why is the Fair Work Act slightly different to the modern award provision? Well, apparently the difference is to provide employees with a different avenue for raising a dispute about the right to disconnect. So that is, rather than going through the general protections framework under the Fair Work Act, they can rely on that modern award provision to go to the Commission and claim that the employer has breached a term of the award. The second reason would be that it provides clarity for where an employer can actually contact an employee outside of work hours and not be in breach of the right to disconnect, which of course is a much less controversial addition. Overall, the disparity between the Fair Work Act provision and the modern award provision is likely, in my opinion, to lead to disputes because of that extra obligation that it apparently places on employers and the use of that ambiguous term indirectly, which leans into the subjective perception of an employee. My tips for employers to deal with this, I would suggest that if modern awards apply to your business, get a copy of all of those that apply, really study the right to disconnect clause and ensure that you understand it, and then communicate that to your employees and make sure they understand it too. I would suggest that you look at your workforce and think about which employees this provision is likely to affect. It's more likely to affect your lower paid award covered employees as compared to your higher paid salaried employees. Think about whether in practice you do contact those people outside of work hours, and if so, how much disruption you're actually causing to them. If you are looking at implementing a right to disconnect policy, as a lot of employers are, focus less on restating what the right to disconnect means and focus more on your workplace dispute resolution provision, because the parties are required to try to resolve a dispute at the local level before they can proceed to, for example, the Fair Work Commission. So using that dispute resolution clause in your policy could really help to nip issues in the bud early. If you did want further information about this topic, you are most welcome to view my detailed article on the Employee Safe Legal website, or you can contact me using the details on the slide. Thank you.